5, 4, 3, 2, 1. The question is whether the first respondent was present at the time of death or was away in the village of DW1, his brother-in-law. It is rather most unfortunate that these witnesses, one of whom was an advocate having given the statements about the facts within their special knowledge under section 161 recorded during investigation, have resiled from correctness of the versions in the statements. They have not given any reason as to why the investigating officer could record statements contrary to what they had disclosed. It is equally settled law that the evidence of a hostile witness would not be totally rejected if spoken in favor of the prosecution or the accused, but it can be subjected to close scrutiny and that portion of the evidence which is consistent with the case of the prosecution or defense may be accepted. One clinching circumstances was that PW2 and PW6 had heard some quarrels in the house of the respondents and the deceased was crying out is not on record as substantive evidence. PW2 and PW6 had no regard for truth. They fabricated the evidence in their cross-examination to help the accused, which did not find place in their section 161 statements that they had seen one man of white complexion and aged between 30 to 35 years going to the house of the deceased on the fateful night and leaving the house at 8 a.m. on the next day. The first respondent has introduced two theories which some stranger had come to his house on the evening of 26/9/1985. He slept in the house and left the house on the next day, that is 27/9/1985 at 8 a.m. This was spoken of not only in his statement made under section 313 CRPC by the first respondent but also, as stated above, in the evidence of PW2 and PW6 in their cross-examination. PW2 Biswas Kumar, a neighbor of the respondents, and PW6 Harsveer Singh were examined to prove the prosecution case that on the intervening night of 26/9/1985, 27/9/1985, they heard quarrels emanating from the house of the accused and the deceased was heard crying, but they turned hostile at the trial and were duly declared hostile and were cross-examined. PW6 is none other than a practicing advocate and a colleague of the first respondent. Equally, PW5 Alok Dwivedi is another practicing advocate who was also examined to prove that the first respondent himself and one Awadh Vishwakarma advocate together had gone from the court with the written report KA3 signed by the first respondent to the police station and had given it at the police station Karvi at about 2 p.m. DW2 Bhavendra Kumar Singh, an advocate of 20 years standing and the senior of the first respondent, was examined to prove the alibi. It is most distressing to note that practicing advocate PW6 and DW2, with a view to exculpate the first respondent from the clutches of law, have without any compunction spoken falsehood and have no regard for truth, betraying their duty of being responsible law officers who are expected to uphold truth and nothing but the truth. DW2 has spoken falsely that after the first respondent got the news of the death of his wife, he was often fainting and swooning which was not even spoken by the first respondent in his section 313 statement. On his own showing, the first respondent had argued bail applications and attended other cases even after he had the news of the death of his wife. In those circumstances, the plea of fainting and occasional unconsciousness is incompatible with stone-hearted Ramesh Prasad Misra. He did not exhibit normal human conduct of an innocent man, that is, he should have been shocked to hear the news of the death of his young wife, married just 5 months back, and an expectant mother of his child in his absence. He should have rushed home to find out the cause for the death and search out whether the crime was for gain, etc., and immediately swing into action and make the police investigate into the crime. On the other hand, although he had the news at 11 am, he went to the police station at 2:10 pm after finding no escape from further delaying the reporting to the police of the crime. This conduct is inconsistent and incompatible with normal human behavior of an innocent man, but seems to be one of a clever demeanor. The evidence of DW2 regarding occasional faints and swooning and ultimate unconsciousness is a bunch of tissues of lies unsavory to be accepted. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.